Good evening, and I'm pleased to be here. Uh, and thanks so much for inviting me. And I'm debating, and usually I go ahead with things I'm saying maybe I shouldn't go ahead with. But I've been um, saying something for a number of years, at least 25 or 30 years. And I wonder how many of you in this Virginia Progressives organization would agree with me when I make a statement that to explain some things that's happening in society, I argue that, uh, in fact, there's something that happened recently that I said really revealed this schism that I'm about to propose, and that is between liberals and progressives. And it's kind of related to some of the things we're saying, and we can talk about a bit about this at the end when we talk about what should we do. I argue that liberals think our institutions are fine and dandy and solid, just need to be tinkered with here and there to make improvements and so on. And I've been arguing, not in front of a group calling themselves progressive, but I've just been talking about this in public, saying that progressives know better. They know that many of our institutions need to be restructured. And the issue is just how much and what kind of restructuring. Those are kind of debates that people can have if they arrive at the point of understanding the nature of the problem, and that is that they need to be restructured. So I wonder if I have a lot of people among you who disagree with me on that. Maybe I can ask you that later at the since you're all muted now. Maybe I can ask you that at the end. But what I want to talk specifically about here is one of the critical issues as I see it in American society. And it's directly or indirectly related to many of the other things that are happening, and we can talk about that sometimes at the end. But look at this. Between 2013 and 2016, over 4,000 American citizens were killed by police officers. Only 85 of these cases led to an officer being charged with a crime. And in only 6 of these situations did we arrive at a conviction of an officer accused of committing a crime. And this statistic holds even though a sizable minority of these people were unarmed when they were shot and killed. In fact, police violence is a leading cause of death for young men in the United States. And over the life course, an African American male stands a 1 in 1,000 chance of being killed by a police officer in their lifetime. Blacks are killed at 3 times the rate of whites, and whites are killed much too often. And blacks are 30% more likely to be unarmed when they are killed. And you should know that since the George Floyd killing and since all those demonstrations all over the country and all over the world, the police killing of blacks have continued unabated. There has been no diminution in the number of, of people killed by police officers and the disproportionate number of blacks killed by police officers. There have been no changes. And so, why is that? I want to offer about 3 things here this evening that I think are key issues in why this occurs. Now, I'm not saying they're the only issues, but I'm going to argue that they're primary issues. Uh, One is if you perceive that the police seem to have a license to kill, well, I'm here to assure you that they do. And I would argue that they got this license to kill in 1989 with a Supreme Court decision in Graham v. Connor. Uh, and it was about the police use of force. So permit me now to just give a little background on this. I am going to presume that most of you have seen the video of the African American male being shot and killed in North Charleston a couple of years, 2 or 3 years ago, uh, in the back as he ran away from a police officer who had stopped him because of some supposed problem with the vehicle the black man was driving. But he was shot and killed as he was running away. Uh, if somehow this person running away could have been characterized as a felon, and I think in this situation it would have been quite difficult to do that, then that was quite legal in the United States up until 1984. It was called a fleeing felon law, that the police had the ability to shoot the fleeing felon and kill them if necessary. So using force against a fleeing felon was something widely accepted until the police in Cincinnati, I think it was, some city in the middle of the country, like Cincinnati, where police shot and killed a 15-year-old black boy who had snatched a purse with $15 in it and was trying to escape and climb a fence. To do so, the police shot and killed him in the back. And this was a 15-year-old boy who was smaller than the average 15-year-old kid, so he looked even younger. And his parents took that case all the way to the Supreme Court. And in the case Tennessee v. Garner, their family name was Garner, the Supreme Court pretty much outlawed the fleeing felon rule that police had operated on. Okay. 5 years later, in 1989, there's another case that gets to the Supreme Court that questions the police use of force. And this was the Graham v. Connor case. And this case changed the way of looking at whether use of force was appropriate. In the Garner case, the issue was the Supreme Court decided that this was a violation of Garner's Fourth Amendment right against search and seizure. So the issue here was whether an individual's rights had been affected by the police officer. In the Graham v. Connor decision, the decision written by Chief Justice Rehnquist, I don't remember whether he was Chief Justice or not, but anyway, he at that point, but he wrote the decision. They changed Garner such that now the issue was not whether or not the individual's rights had been violated, but whether or not the police officer was within his or her rights to have used force in this instance. Now, there were a lot of other conditions they laid down, but I argue that this is a key one because it changes from individual rights to then determining whether a person is doing their duty appropriately in their profession, that is the police officer profession. Okay, so it's a shift from the citizens' rights to the rights of a person in a profession, the police officers. And there's one statement that's in this case that I hang most of my criticism on, and that is a statement that Justice Rehnquist made when he said, in effect, that you cannot apply post hoc analysis to whether or not use of force was applicable in this situation. You must judge it on the basis of a reasonable officer in the field. And I'll go a little bit further with that and say, if a reasonable officer feared for their life, then they should have right to defend themselves by the use of force. And if you find out later that there was no gun, that the police officer said, I thought he was reaching for a gun, you can't do that post hoc analysis. You must go back to the point in time where the police officer could fear for their life or not fear for their life. If they said, I thought he was reaching for a gun, basically that's where you get with this so-called reasonableness standard. Now, some people have cautioned me on going where I go with this, but even these people will admit that in many instances, whether that's what the law says based on the Supreme Court decision or not, that is what happens. In other words, there's a presumption that the police officer can fear for their life if they think something that may not be true. And to drive this point home, I want to tell you just a little quick kind of story. Supposing you, any one of you, were at some meeting, supposing you were all in the same room together, and say person A would take out that gun and shoot person B. And the police officer said, why did you do that? He said, oh, I thought when he reached into his coat pocket, he was going to get reaching for a gun to shoot and kill me. And so I had to act first. Now, not any one of you listening to me now would believe that that would be a reasonable defense. No citizen could use that as a defense, yet police officers can. And I question whether that is constitutionally correct, even though it came in a Supreme Court decision. I have issues with that. So there's another issue that some people discuss, and that's the qualified immunity, but I won't go into this and I'll tell you why later. So I'm saying that Graham v. Koenig provides a license to kill, but police union contracts shield police officers from prosecution. I'm slowing down because I want you to know that I am not exaggerating. So let me try to explain. Campaign Zero, which was organized by Derek McKeeson, who was one of the leaders of the Black Lives Matter movement, has studied over 500 police union contracts. Something approaching 600 have been studied, and most of them are problematic. Most of these contracts limit officer interrogations after their alleged misconduct. Most of these contracts mandate the destruction of disciplinary records. And that's why you can have sometimes a person who has a bad record of employed in one police department and is pretty much dismissed, can go to another department and go to work because there's no record of their wrong deeds. Many police union contracts ban civilian oversight. So civilian review boards can't be used in some jurisdictions in this country because the union contracts prohibit any external agency reviewing the work of the police organization. Union contracts, police union contracts, by and large prevent anonymous civilian complaints. In other words, they argue that it must be something formal. It must be formally done. It can't be someone calling in making anonymous statements about something happening or not happening. And these police union contracts tend to limit the amount of time that officials can take in investigating alleged police misconduct. One of the most egregious provisions of these contracts is the limitation they place on the interrogation of officers. Imagine if before interrogating a subject, a regular police officer had to provide the suspect with written statements from all witnesses with knowledge of the crime. Imagine if before conducting interrogations, police officers were required to give suspects and their attorneys a full and truthful accounting of all the evidence against the person. Imagine if police were required to provide all suspects and their attorneys with advance notice, anywhere from 24 hours to 10 days in length, before conducting interrogations. Now, if that situation exists, police departments would resist it, and they would proclaim, rightfully so, that such restrictions would make it difficult for them to prosecute criminals. Yet that is precisely what many of the police union contracts require when the suspects are police officers. Thus, we have one set of procedures for citizens, we have another set of procedures for police officers. And when we get into established procedures that are different for police officers from everyday individuals, let me go to a third issue I want to raise here. And that is the Law Enforcement Officer Bill of Rights. About 20 states have passed legislation to provide police officers with a Bill of Rights. In other words, providing them guaranteed rights that citizens don't have. For example, Virginia is not that bad considering some of these conditions under the what we call LEBOR, the Law Enforcement Officer Bill of Rights. But Virginia does have that. And they got it through the pressure and the prominence of police associations. In Virginia, any prosecutorial group authorities will have to wait 5 days before they can interview a suspect, a police officer suspected of or accused of wrongdoing, including the use of force to the extent of killing a person. 5 days. Most police union contracts or the LEBORs, the average is about 2 days. Some go longer. Virginia is one of the longer ones. Okay. Now, what are the remedies for these three issues that I raised? Or what's the remedy for the problem that I raised, which is the excessive use of force against all citizens and against African American disproportionately so. What is the remedy? Well, one of the things you heard a lot last year in all the demonstrations, we need training. And I won't use profanity tonight, so I'll just say BS. Okay? We cannot train ourselves out of this. We cannot train police officers to not do this because they're being trained to do it. And how are they being trained to do it? These activities should not be focused on individual police officers primarily, even though if that's the case, they should. but it should be on the police departments. So we keep hearing rogue police officers. We need to train them. They're not trained appropriately, so they don't know what to do. No, yes, they do know what to do. What they do is what they should do because they do it with impunity. So that's what they're supposed to do, I would argue, until they're forced to not do that. And the only way they're forced to not do that is have some consequence of their actions. Uh, and to have this consequence, we deal with the police officers, but we must also deal with the police departments. The excessive use of force is condoned by police departments and all too many citizens. And racism in the excessive use of force is an attribute of police departments. In the early 1990s, dealing with some aspects of these issues, Congress passed a bill which is known as the Patterns and Practices Law that enables the Department of Justice to investigate police departments and demand certain actions on these departments. In other words, to take them over and to look over their shoulder for a year or two or three and mandate certain changes to their patterns and practices if the Department of Justice finds that there are problems, especially racial problems in these patterns and practices. When Barack Obama left office, the Justice Department had 25 cities under this kind of investigation, from Ferguson to Chicago and so on, and Cleveland and so on and on. As soon as Jeff Sessions became Attorney General under Trump, he dropped every one of those 25 situations and said, you know, racist police departments, you can just forget it. We're not pushing you, we're not investigating you, we're not demanding things of you. It's all over. Now, the current Justice Department under President Biden has reinstituted 2 or 3 of these, but in my view, not nearly enough. So we need to have more of these cases under the Department of Justice, brought into the Department of Justice to have them investigated and so on. What else can we do? I would argue that we should change the reasonableness standard in Graham v. Connor. I had a discussion with Senator Tim Kaine, who told me that this could be done by legislation. Now, he may be one of the few who think so, but I asked him, couldn't it be, with my assumption that it should be. And he argues that it can be. So one of the things we need to do is to address this reasonableness standard. But where we should spend much more of our time is dealing with police union contracts. So let me tell you what we can do in Virginia. Virginia is a so-called right-to-work state, and therefore public agencies could not unionize until 2020, when legislation was passed to provide public agencies in Virginia to provide the ability of employees of these agencies to unionize. And what that means, I first should say, as I understand it, this went through just like that because mostly unionization tends to be a democratic issue. But this was introduced by a Republican and Democrats signed on immediately. And so what we're trying to do in an organization that I head, we're trying to acquaint people with what my argument here is about the union contracts and what the state needs to do. Uh, we're trying to convince legislators that they need to pass a bill that would limit the content of the police union contracts to just deal with things like um, uh, uh, compensation and benefits. That it should not include things like discipline or so on, which these contracts are full of what you do in the cases of a police officer accused of something. Now, the District of Columbia has reined in this outsized power of police union contracts by forcing a revision of the contracts to take out everything dealing with the discipline of police officers. So they're kind of the idea of what we want. We also know that our colleagues in Austin, Texas, spent 5 or 6 years using all kinds of organizations and people with their own specific interests about what was happening with the police union contract, including those who were just concerned about fiscal issues because they thought all too much money was going to these police departments over what they thought it should be as a function of the city of Austin. So they finally got it changed such that discipline kind of stuff is omitted. So what we're saying in Virginia, we need to limit the police union contracts that are being developed right now across the state. Okay. And in the process, we need to get rid of all of these LIBORs. I think it's absurd that police officers will have rights added to themselves by legislation that citizens don't have. And this is what kind of protects them if they do exercise excessive use of force. Now, let me be quick to point out that the police union contracts are so bad that unions across the country are weighing in and arguing that changes should be made. Much of this probably occurred because some of the demonstrators last summer argued that the AFL-CIO should expel the International Union of Police Associations because of their activities and because their contracts were contrary to labor union movement ideas. The Association of Flight Attendants weighed in. They argued that the police union must address racism in law enforcement or they should be expelled from the union movement. The Service Employees International Union, with some 2 million members, are saying that unions such as those deal with security like police should be accountable for the racial justice or injustice in the place. So they should be held accountable. In Seattle, a labor union coalition issued an ultimatum to the local police union to acknowledge and address racism or be kicked out of the alliance of the local alliance, the labor union coalition. Even a janitors union in Seattle joined in, criticizing the police union contracts. And the janitors union, they argue that if you're going into debate contracts, you must have some community folk there in the discussion and the negotiation over these contracts. And so I would argue those are the kinds of things we need to do to stem the tide of police killing American citizens in general and African American citizens in particular to excess. So I'll stop there and ask whether there are any questions.